Yes.
Only one point to be made, but all senior councils have already made point. Only one
Yes.
regarding 2 minutes, but I'll just bring that to your lordship's notice, my lord. Then item 126 actually appear. That
Yes.
issue was, my lord, regarding Telugu medium students. May I be, sir? Telugu
Yes.
medium students. Yes, for Telugu medium students, the main complaint has been that the papers which are written by Telugu medium students are to be evaluated by, well, the experts from that subject, well, as certified by the UPSC experience, etc. Our complaint has been that the qualified evaluators of that particular subject did not evaluate the papers belonging to Telugu medium students. That was upheld by the learned single judge because the neither the service commission nor the state government could establish that in fact the qualified people in the Telugu medium in that subject literally valued those papers. That was number one, man. Then, but that was issue and mainly false. Second ancillary issue is that when they publish the key, that they publish the key so that everyone candidate can come and tell the commission that this is wrong, right, etc. Even that they did not publish properly for Telugu medium students. They skipped some questions. They did not allow the Telugu medium to do this. But third thing is that most vital would be that though it looks ancillary, the centers where Telugu medium students were there, well, the percentage of qualification has been phenomenally low. But thus, all the Telugu medium students have been, Telugu medium candidates have been discriminated, that they have not been treated. I'm not saying they should be given extra preference, but they have not treated equally. And in fact, they have treated the left-hand treatment. Especially evaluation was not done by the proper people. That is a small issue, Merit, which I raised this. All other issues we raised, Merit, all other senior cons submitted. I don't want to repeat that, Merit. This is the only issue which I want to bring it to your lordship, Merit. And in fact, the government, everyone has been saying that they'll encourage the when Matrubhasha, Bharati Bhasha, and how they are treated, Merit. Right? Matrubhasha ka apman kiya pura. But I'll just request your lordship to look into the particular aspect, Merit. The page numbers, etc. My colleague on record will just pass on those numbers. I don't want to retain your lordship further. The particular page numbers and para numbers, my colleague there, Manad, he'll pass it on.
Very well. Thank you.
Yes, that's all. Much obliged. My other colleagues will continue, Manad. Various other issues are there. I adopt their arguments regarding that, Manad, but this one has been polished.
Please go.
Yeah, only one copy.
Have to see it all. The third page, it is there, Manad. Discrimination against Telugu medium candidates. Page numbers, para numbers have been specifically mentioned. Discrimination against Telugu medium candidates, para 3, 4, 5, 6, etc. The second page, it is there. But this was issue specifically dealt and agreed by the learned single judge because the authorities could not satisfy the Sambal court. I'm sure they did not bring any other material to show that the service commission or the government. This is item 126, and I beg to appear on behalf of Srikanth Reddy.
Yes.
That's all, my lord. Deeply obliged, my lord, for accommodating us. For my other colleagues will be raising other points.
Yes.
Milord, I'm sorry, Milord. I'm sorry, Milord, I'm permitted. Milord, in that Sigachi matter, Milord, officers are present. Milord, your lordship last occasion directed the officer to be present. Lordship may kindly record their presence, Milord. That's all. Lordship may kindly record their presence,
Yes.
Milord.
It's
That's
record the appearance of.
obliged.
Your Lordships, if I may, Your Lordships. May I start, Your Lordships?
Yes, yes.
Your Lordships, I'll be appearing in Writ Appeal 1066, Your Lordships, the heading one. Item
What?
number 114, Your Lordships.
Writ appeal number?
1066 of 2025. It's item number 114 before Your Lordships calendar.
Yes.
Your Lordships, I would, in order to ease Your Lordships, for Your Lordships' convenience, I'll request Your Lordships to just have my IA3 and my written submissions along with 2 volumes, Your Lordships, of the respondents' writ appeal, Your Lordships. I will principally be dealing with 4 aspects, Your Lordships, specifically based on the contention that the writ appellants went to copious lengths to inform this court as to how they went about the conduct of the mains exam and the evaluation process until the declaration of the GRL, Your Lordships. My specific contentions, Your Lordships, bringing all the 4 aspects that I'll be dealing with under one umbrella is to show to Your Lordships, or try and show to Your Lordships, that the why has been explained, but the how, or rather the how has been explained, but the why, the reasoning behind the same has not been explained, has not been elucidated, and has not been clarified in any form before the Hernet single judge, Your Lordships. Because the why, although was tried to, in order with all fairness, was tried to be explained, the rationality or the logic behind the why has not been explained to this date, Your Lordships. Your Lordships, my first point will be on the evaluations, Your Lordships, the 2 evaluations and 3 evaluations. My seniors made several arguments about the 2 and 3 evaluations. The one aspect that was not explained to Your Lordships is the importance of the OMR, Your Lordships. And OMR is not just a sheet, Your Lordships. It's not just a sheet. OMR, optical mark recognition, is a technology. It's not a sheet. It's a technology. Here, Your Lordships may kindly come to page 788. It's in the 2nd volume, Your Lordships. The volumes are divided into 7 volumes, but 5 volumes are in volume 1 and volume 2. 788 clearly shows the TGPSC's OMR sheet, Your Lordships. The OMR sheet of the TGPSC, as has been shown, Your Lordships, has evaluation 1, where the evaluators are supposed to mark, grade the different marks, and this is important, yes, but this is prominent. This is the decisive aspect. The same numbers, the same evaluations that are given here, the numbers 10, 8, 7, because each one is out of 10 marks. Whatever marks are marked here are supposed to be bubbled here. If it's 7 marks, 7 bubbles. This has been followed for evaluation number 1 and evaluation number 2. I'm not before Your Lordships on the number of evaluations they informed us, they haven't informed us, no. I'm on the seminal aspect of the OMR. This, yes, grading, 7 marks, 6 marks, they might even remove it or change their mind, but there cannot be any change of mind on the OMR. There is absolutely no leeway, no flexibility for change of mind on the OMR. Once you decide 7 marks, 6.5, 5, 8, that has to go here. The same repeats here. Once
Please.
you decide on this,
Since you brought about that half mark, how would a half mark be indicated on that?
Your Lordships, they have to explain that.
No, no.
I'm only bringing it to Your Lordships' attention that once the mark, if they might round it up to 7. I mean, I'm only.
No, because you said 6.5, perhaps I thought you.
I'm only hedging, Your Lordships. Here, the OMR is decisive and fundamental, where once marked cannot be changed, cannot be flexible, it's done, Your Lordships. This has been followed for 2 evaluations. evaluation number 1, evaluation number 2. However, as an afterthought, the reason why I'm saying it's an afterthought is I'll come to your lordships. On page 4, on page 3, page 1, page 2, after instructions, after detailed instructions, on page,
These are on which page?
this is on page 788. This is the second bundle, your lordships. All volume 1 to 5 are in 2 bundles. Second bundle.
Volume 3.
It's in volume 3, your lordships. No, it's actually in volume 4, your lordships. Volume 4, page 788. Therefore, your lordships, I do not, my impetus before your lordships is not the marking. They can give 7, 6, whatever they are experts or claim they are experts. It is this OMR that is seminal, that is decisive, that is the reason why manipulation is likely to creep in. This OMR being decisive is for evaluation 1, evaluation 2. Then your lordships, the second page is for instructions. Now your lordships may see the third page, page 790. At the bottom end, there is the alleged or the very controversial third evaluation, 790. This third evaluation does not have any room for the OMR marking, your lordships. The OMR marking, the reason why, the optical mark recognition, that's the full form. The optical mark recognition is a technology where this paper, I'm just demonstrating, your lordships, this paper is run through the machine. And once this paper is run through the machine, this is not relevant. The machine only marks, saves, captures and saves these two. This is the only thing that I, as an aspirant, I am assured that my marks, once being scanned and captured by the OMR, are safe. I do not, it's open to anybody's interest. Now this, the all-important third evaluation does not have. This OMR sheet, there is no OMR for third evaluation. What is claimed by the respondents is, and I will take your lordships through the common counter on page 937. (935). Your lordships, what is stated at 937 is, your lordships, I'm going, allow me to read, your lordships. I'm at paragraph 64 of their common additional counter. This common additional counter was served to all of us, your lordships. I'm at page 937. 937, paragraph 64. I am coming to the middle of the paragraph, your lordships. I'm from owing. However, the answer book has been stitched, etc. The stitched part of the answer book, the barcode running along the answer script. This part of the answer script containing barcode remains undetached even after the OMRs for the first and second evaluations are detached. Owing to the barcode on the stitched portion of answer script, the third evaluation form can still be identified with the same barcode given on the answer script. The third evaluation form also has the provision for signatures of evaluator, chief examiner and scrutinizer. The OMR valuation form is scanned after each evaluation in the interest of integrity of the evaluation process. Since the third evaluation form has the signatures of the evaluator, chief examiner and scrutinizer, there is absolutely no scope for manipulation. Hence, it is a false allegation that the third evaluation is exposed to manipulation. This cannot fundamentally fly, your lordships, because the third evaluation, by the appellant's own admission, they have stated that it is the third evaluation that had the difference of 15% marks, and the number of such differences came up to at least conservatively 5,000 scripts. Therefore, I as an aspirant, without the OMR being scanned and captured, and permanently so, there is, your lordships, the preliminary exam, your lordships had the opportunity to review the preliminary examination sheet as well. There it is objective, and there also we are required to only bubble our choices, A, B, C, hubble. Once there is any manipulation or any kind of a revision or whitener used, or some kind of an ink used, etc., on the bubbling, it is termed invalid. The OMR technology, the OMR machine does not read that OMR sheet, and there are tons of writ petitions pending in His Honorable Court and all over India. Therefore, the same OMR being very, very suspiciously missing from the most important evaluation nullifies the entire evaluation right off the bat. And the third evaluation, your lordships, on page 790, your lordships would see, is an afterthought. Is an afterthought. Why I say that? Because they did not come out with 3 evaluations all at once. They came with, first they were inclined for 2 evaluations, and then they changed their mind to a third evaluation later on. Your lordships, in the month of August, and the web note relating to the August month also is here, your lordships. In the month of August, there were only 2 evaluations for the TGPSC mains exam. I've also, for your lordships, it's a live link. I can also, from any instrument, click on the live link. But for your lordships review, I've printed it out. In the month of August, your lordships, there was only 2 evaluations, and this script was published along with the web note on page 1008. The web note dated 16/8/2024. It says nothing about evaluation process, how many evaluations, the mode of the answer script, nothing. But with the web note that says about the timings, etc., it's for your lordships review again in their material documents at page 1008. Along with this web note, that is the answer script that was published. Then, in the month of August, now at the end of September, on 27/9, another web note was published, again not dealing with the answer scripts, not dealing with the mode or method of evaluation, nothing. Another answer script was published where the third evaluation box is very forcibly inserted after the instructions, and somehow, I'm giving them the due, they might have forgotten to include the OMR, or the OMRs were already done and taken care of. Another important aspect your lordships may see. I'll take your lordships once again to 788. Your lordships, after 788, your lordships, the respondents also included the APPSC's OMR sheets. Your lordships may see. The APPSC's OMR sheets is on page 791. The APPSC Group 1 mains OMR sheet has first evaluation, Importantly, OMR. It's on page 791. Immediately after the TGPSC. 791. This is the second bundle, your lordship. The volumes are divided. Volume 1 to 5 volumes are divided into two bundles. It's in the second bundle.
Yes.
791. It's immediately after the TGPSC owner. Now your lordships may see one page, the point for marking all three evaluations, and for the OMR machine reader, the optical mark recognition machine to read the marks. First evaluation, check. Second evaluation, the place for the evaluator to write the numbers and for the optical mark recognition machine to scan and capture the marks. Evaluation 2, check. Third evaluation, for the evaluator to write the numbers, mark the numbers, and for the evaluator to insert his markings in the OMR scanned area so that the marks can be scanned and captured permanently. This is all in the line, your lordships, and the reason why I say it's an afterthought is then the instructions start. But here your lordships may see the third evaluation exists after the instructions as an afterthought where they included it inside. The barcode also, your lordships, in the same set, your lordships may see. Your lordships have the two aspects. The barcode. Hence, there exists no third evaluation for the TGPSC mains examination, and all the statement about 15% change and it goes to the scrutinizer, chief examiner is humbug, with great respect. Cannot be believed, cannot be trusted. Because more than out of 21,000 change answer scripts, your lordships, they themselves conservatively estimated at least about 5,000 papers went for third evaluation. How are we supposed to trust an examination where the OMR exists selectively for two evaluations and not for the third evaluation, when the same OMR for another group 1 examination is consistent? The aspect about the barcode. So the evaluation just based on this has to be nullified, because examinations have been nullified based on the manipulation with the OMR. Then the barcode, your lordships, it was explained. This is the barcode where our details are stored. There exists no barcode for the third evaluation. No barcode. This is not the one, your lordships. This is the barcode where evaluations are, even by their edition, even as explained at length by them. This is the barcode. Hence, your lordships, there exists this aspect of third evaluation, 15%. Your lordships, may I inform this court that entrance examinations, there is a difference between relative merit and absolute merit. Entrance examinations are about relative merit. Here, I am not out to prove that I'm a 90 percentile person or 100 percentile person. I am only out to get more marks than my contemporary or my competitor, and to get that job or to get that entrance. Therefore, every 0.5%, your lordships, even the people who have been selected under duress, or rather after the bond, after the signature of a bond, even 0.5% is a difference in about 20 to 30 marks, your lordships. Therefore, the third evaluation is equivalent to no evaluation, is my first respectful submission. Then your lordships, a lot has been stated about the fact that the mains examination to this day, to this afternoon, there is no number as to the number of people who have appeared for the mains examination, your lordships. Your lordships, because everything is on a go. Everything is free for all. Because every time we have brought certain aspects to this honorable court's, or rather the single judge's attention, the numbers kept changing. My second point is about the fact of biometrics, your lordships. But what has been explained, I'll not elucidate on that, your lordships. I will take your lordships to the first volume, your lordships, annexure 6 in the notification. Annexure 6 in the notification is at page 405. This is the first volume. Your lordships may only, for your lordships' convenience, keep in mind that there are just 3 bundles. The relevant are in just 2 bundles. Just your lordships may keep just 2 bundles with your lordships. The second point, the first point is that there exists no third evaluation and the entire third evaluation ought to be scrapped. The second point is on the biometrics aspect, your lordships. At clause 6, your lordships may see this is the complete notification, your lordships, and this is one of the annexures of the notification. At clause 6, your lordships may allow me to read. The candidates shall report to the examination venue 1 hour before the commencement of the examination to record their photo image, thumb impression on the biometric system. The entry gates of the venue will be closed half an hour before the commencement of examination. No candidates will be allowed into the examination hall after closure of the center venue gate. Loaning and interchanging of stationery, etc. The candidates will not be permitted to leave the examination hall till the expiry of full time. If any candidate leaves the examination hall in the middle, he/she is disqualified. Your lordships, the biometrics, it's on page 405, your lordships.
Yes.
6.1 clause, your lordships, of the annexure. The biometrics is the seminal for the conduct of the examination and for recording of not just whether to see if I'm impersonating somebody, it is specifically, necessarily for the purpose of attendance.
Yes.
In spite of the fact that, again, in the first instance of evaluation, there is no machine reading. For third evaluation, no OMR machine reader exists for the third evaluation. Once again, something that ought to be captured by a machine, biometrics machine, there are varied numbers coming to this day, and I'll demonstrate why there are so many numbers, your lordships. Your lordships, this is the requirement for biometrics, and your lordships, my senior earlier had spoken about the specific single judge's judgment in the preliminary exams based on which it was cancelled because they did not get their numbers right and there was actually no biometrics in place. The first time it was cancelled for paper leakage. The second time it was cancelled because there was no biometrics examination, and we are before your lordships for the third time. And once again, there is a malfeasance as far as biometrics applicability is concerned for reasons best known. Now your lordships may come to the number of times the entire premise keeps changing. Your lordships, I will not take your lordships through page 426, which deals with the learned single judge's decision. Your lordships have it. I'm not going to go through it, your lordships. Now your lordships may come specifically to your lordships at page 438. This is the final GRL 438 is the final GRL, the general ranking list, that is 21,085. 438. On 30/3/2025, the final GRL is 21,085. On 21/10/24, at page 432, page 432, at page 432 is total number of candidates who appeared for all 7 papers, 21,093, that is 21,075 plus 18 sports candidates. The third part of the column, your lordships. This is on 21/10/2024. The same is repeated again on 27/10/2024. This is on page 434. So 432 to 434 are the 2 days, are the 7 days when the entire examination process was going on. This recording the appellant submit is it as manual attendance on the go, subject to change. Manual attendance on the go, subject to change. I'll come to the 21,093 in a moment, your lordships. So, in the month of October 2024, it is 21,093. Then, in the month of March, the GRL, the final GRL on page 438, the number is 21,085. Then, in the middle, your lordships, on 13/3/2025, on 13/3/2025, your lordships, this your lordships would find on page 447. 447. 447, specifically on 449. 449. On 13/3/2025, the numbers are overall performance total candidates 20,161. For this, the explanation of the appellants to your lordships is, we only gave the numbers of the people who qualified in English, minus 934, etc. So I'll repeat once again, your lordships. 21st to 27th of October, 21,093. That is 21,075 plus 18 sports candidates. Come 13 March 2025, according to them, although nothing about qualification is written here, very happily they claim it is 20,161 minus 934 or 936 candidates. Then again, immediately in the same month, the very mysterious GRL at page 438, which is under challenge before your lordships, states it is 21,085. Now your lordships may come to their submissions. Your lordships may now take this second volume, your lordships. Your lordships, may I continue, your lordships? Now the second volume, your lordships. The further change, as questions keep coming from your lordship's bench, how it changes. Now your lordships may take the second one. This includes volume 4 and 5, the second one. Now your lordships may come to page 740, your lordships. 740. This is the vacate stay petition filed in the month of April 2025, on 30th April 2025. Vacate stay petition filed on 30th April 2025. Your lordships may come to page 740. Here, this is in the reason why the dates are important, your lordships, because they filed 3. Your lordships, page 740, this is the first vacate counter filed in high case in writ appeal number 1066, or rather the writ petition. Page 740, that it is further submitted that the above entire process has a reconciliation step and it is being implemented by the commission in all recruitments being taken up by the commission. Hence, it is reiterated that after reconciliation of the OMR answer sheets, nominal rolls, etc., the final figure arrived is 21,085. Their statement, your lordships, 21,085. Now your lordships may come to page 912 in the same volume. Page 912. This is the common additional counter. The common additional counter filed in all, or rather filed in all petitions, your lordships. This was filed in the month of June. Your lordships make 912. They elaborated copiously. Now your lordships may see it is there, the tabular column. On 27/10/2024, their number is 21,093. Their number is 21,093, as was stated on page 432 to 434. Then on 30/3/2025, their number is 21,085. Your lordships. Then on 13/3/2025, their number is 20,161. Your lordships, now your lordships, what is important is their explanation. Your lordships, I am in the same tabular column. Your lordships may allow me to read 33/2025, the explanation, their remarks, your lordships. Your lordships, a total of now the new, with great respect, the new aspect, angle of this number kicks in, your lordships. A total of 21,110 candidates wrote all 7 papers. The results of 25 candidates were not included in the total marks list of candidates as per orders of this honorable court. Therefore, the results of 21,085 candidates, 21,110 minus 25 were released in terms of the total marks list. 21,110 is the final figure of candidates who wrote all 7 papers. Your lordships, this is germane. 21,110 is the final figure of candidates who wrote all 7 papers. Now your lordships may be wondering, now once it was 21,093, then it came down to 20,161, then it rose to 21,085. Where did 21,110 come from? This, your lordships, came from this. I'll explain. Your lordships may come to, Your lordships may come to page 797. I am only arguing before their lordships from their writ appeal. 797. This, your lordships, we produced before the learned single judge, completely listing out the number of writ petitions, the candidates filed, the sports quota people, as well as other writ petitions filed on in group 1 where marks were withheld or they were allowed to write the examination, your lordships. So it is 18 sports category exists. The number 18 of sports category candidates. But what about the other 7? When we produce this document clearly stating that more than 18, they in 21 on 21 10 and to 22710 they claim it is 18 sports candidates. No, in addition to 18 sports candidates, there were 7 more candidates who were allowed to write the examination. After we submitted this list of 25,000 candidates along with their writ petition numbers, their hall ticket numbers and their names, your lordships, 18 plus 7, that is when the new song came out. That is 21,110 is the final list. This 21,110 has again been repeated in the writ appeal also. There was an intra-court writ appeal filed on the stay granted in this writ petition. And in this intra-court writ appeal, your lordships, I have included the writ affidavit in this IA3 that I filed, your lordships, additional material documents, at page 89. And in this intra-court writ appeal also, at page 98, they claim it is further submitted that the above entire process of reconciliation step and it is being implemented by the commission in all recruitments being taken up by the commission. Hence, it is reiterated that after reconciliation of the OMR answer sheets, nominal rolls, the final figure arrived is 21,085. They contradict their own affidavits under oath. 21,085 in the GRL, 21,085 in the vacate counter filed in April, 21,110 in the common counter filed in June, and 21,085 in the writ appeal, in the intra-court writ appeal counter. Now, your lordships, again, your lordships, this sheet was circulated before the single judge and your lordships also. The learned senior, the commission has circulated to your lordships. I am circulating it for the second time, your lordships. Once again, from 21, when they have clearly in their tabular column at page 912, clearly stated, therefore 21,110 is the final figure of candidates who wrote all 7 papers. This was circulated before the learned single judge as well as to your lordships when the appellants were arguing. Once again, Group 1 service mains examination, center-wise overall and female percentage of pickup. Your lordships may see the total. It's 21,085. Your lordships, after the UPSC, for every and any state, the Group 1 is the primary recruitment examination and one of the most important recruitments in any state. This, when you do not know, and where marks, or rather where recruitment or where jobs are lost by 0.5% to less, your lordships, this is the stage. We do not know to this day if it's 21,085, 21,093, 21,110 or less. And tomorrow, if another query falls from your lordship's bench, there will be another repeat and an explanation for that, and eyewash for that as well, your lordships. No third evaluation, subject to a machine that has to read. Biometrics, a machine that records the attendance. They claim about manual, they claim about reconciliation of attendance, they claim everything. They cannot reconcile the attendance taken in the morning, in the evening. There is no reconciliation to this day, your lordships. I'm done with that point, your lordships. The third, your lordships, is the provisional marks list. I'm done. Just two more points, your lordships.
2 minutes.
Your lordships, just two more points. Your lordships, giants have argued before me, your lordships. Your lordships may give me some time. I'll complete it. I'll complete it in record time, your lordships. I'll complete by 3:30. I'll complete, your lordships. Your lordships, the third.
5 more minutes after 3:15.
Your lordships may kindly, your lordships, I bowed before your lordships. Your lordships may kindly grant me until that time, your lordships, because here, your lordships, everyone has argued what they had to argue. I just want to bring two aspects to your lordships. This thing, and
those two aspects.
Your lordships, and there is case law. That is the reason. I'm not going to go into the background of the case law. I'll just read the important aspects. Your lordships, the third aspect is the PML. PML was gone into in detail. The aspect of 15.2 and 15.3, your lordships, is the fact of publication. Publication is not something where something is thrown in my face in my login. Publication is where I can see everybody else's, or I can see my competitors. Given the fact of, yes,
we
your
have
lordships.
followed that point. We are going to put that question to them in
Yes,
the
your
reply,
lordships.
so you did not labor.
That is the reason in my writ, in my additional the web note of 5.3, your lordships, the web note of 5.3/2025, which I have included in my IA as well, and it was gone into your lordships. They specifically include sending it to the email as well as publication. The reason why it becomes important, now I will start tying up the ends, your lordships. Here, the reason why everything is manipulated, your lordships, is because it starts with the fact of the hall tickets. Once preliminary hall tickets without any kind of reason are transferred, or rather the preliminary hall tickets are cancelled and a fresh set of hall ticket comes into existence, your lordships, I am blinded for the first time. There is a 3-round blindness, your lordships. If your lordships cards, I mean, I sometimes try to learn it. I haven't been successful, but there is a triple blind happening here. Once the preliminary hall tickets are removed for reasons best known, without any kind of information or reason other than administrative convenience, the second part, the mains hall ticket, a new set comes about. It does not matter that the prelims hall ticket is also reflected on the mains hall ticket. Nobody other than the candidate can see. So the first blind starts from the change from preliminary to the mains hall ticket. Then I am blinded. Now, then the second blind is where you completely remove, or rather you completely violate not just the biometric system in the annexure at 6.1, but also 15.2 and 15.3. Once, your lordships, provisional means that something after will be changed or is subject to change. I've included it in my written submissions. Once provisional that was clearly mandated and agreed to have been published is not published, the second blind happens. Now, I do not know whether the prelims candidates wrote the mains exam. I do not know whether the mains candidate who are finally shown in the GRL are the candidates who have qualified in the preliminary, or if I should apply for recounting or not. Because once again, absolute merit and relative merit kicks in. And the reason why I'm saying the first mischief starts with the hall tickets is because, your lordships, they claim that the preliminary hall tickets, the mains hall tickets, it comes about after a Russian roulette process of randomization. Once randomization is reclustered into women candidates, women centers, male candidates, male centers, co-ed candidates, or rather neutral centers or PWD centers. There remains no reason for randomization. So the entire process of randomization, or this Russian roulette tranche that has been brought about before your lordships, is a farce. Preliminary is already randomized. Again, you randomize it only for the sake of reclustering it into women, men, and all. All of this double blind game has been played for your lordship's convenience, only and only for the sake of a few candidates. And the entire evaluation process was gone into length by the others, your lordships. The fact remains that even subject-specific evaluators were not there, and I've included in my writ affidavit, where economy, along with, I'll just once, your lordships, at page, in the web note on 13/3/2025, your lordships, 13/3/2025.
We have seen that.
Yes, your lordships. There, your lordships, there is a tabular column, your lordships, which states the number of evaluators and their subject expertise. There was economy and development, but that economy and development also included environmental studies. Osmania University, JNTU, and Ambedkar Open University in Telangana have departments dealing with environmental studies. There was 50 marks question in the general essay dealing with sustainable development, and a 50 marks essay in the Haynes examination dealing with climate change and Paris Protocol. There was no subject expertise as well, and the Telugu, and I won't go into that. Your lordships, here, specifically the aspect of randomization, the hall tickets as well as the provision, and the fact that the OMR, the third evaluation, had absolutely no provision for the machine to read the evaluation itself, nullifies the entire evaluation, your lordships. I'll just, where is mine? Your lordships, I won't take your lordships through most of the compendium. Your lordships may first come to page 23 of the compendium. Page 23, and I've tagged your lordships. Page 23, your lordships, at page 33.
Which of the judgments which you want to rely upon?
Yes, your lordships.
Just
three.
indicate.
Just three. This
Which
is
one?
the
Serial?
all judgments are important, but specifically at page 23, your lordships. This deals with the fact of there was a query.
Serial number.
Serial number 2.
Very well. 2.
Serial number 2, and I've mentioned the page numbers also, your lordships. Serial number 2. Now, this deals with the fact that, your lordships, this is again a mass malpractice case where the case went to the CBI, and it is presently with the
Lords, I'm sorry to interrupt my friend.
Deal with the
but
aspect of.
Could we
I'm
have the
only
name
here
of
to
the judgment,
specifically
please?
Deal with the.
No,
I'm sorry to interrupt.
don't have to explain the judgment.
I'm not explaining the judgment, your lordships. One
I'm
specific
sorry to
aspect.
interrupt my friend,
They
but
claim
could we have
about-
the name
they
of the
claim
judgment,
about
please?
proof.
Can we have the name of the judgment, please, my lords? Because
Your
it's
lordship.
just serial number.
Your lordships, the judgment, your lordships.
No, she is referring to one state of West Bengal versus Vaishakhi Bhattacharya.
I'm grateful. I'm grateful, my lords. I'm sorry. Thank you.
Your lordships,
No,
your,
please, we have read this judgment.
your
She
lordships,
just-
I'm not trying to explain the judgment. I'm only counteracting a point made by them. That point only I'm going to make for your lordships. I'm only stating regarding the aspect of proof, your lordships. This judgment clearly, this judgment at paragraph at page 40, your lordships. I'll just read page 33. The court observed that determining when the examination process is vitiated by irregularities requires an in-depth fact-finding inquiry. The answer lies in examining whether the irregularities were systemic enough to undermine the sanctity of the process. In some cases, the irregularities may border on and even constitute fraud, which severely damages the credibility and legitimacy of the process. In such cases, the only option is to cancel the result entirely. These are situations where it is difficult to separate the tainted from the untainted participants, and the irregularities are widespread, indicating malaise. Your Lordships, the standard of proof on page 39 and 40, Your Lordships. The standard of proof, it was given in Vanshika and it has been taken into this on page 39. The standard of evidence need not be unduly strict. Specifically, the material on record need not point to a single definitive conclusion that malpractice occurred at a systemic level. Nevertheless, there must be a real possibility of systemic malaise as reflected in the material before the court. The decision to cancel the selection en masse must be based on the satisfaction derived from sufficient material collected through a fair and thorough investigation. It is not necessary for the material collected conclusively to prove malpractice beyond a reasonable doubt. Here, Your Lordships, there is enough copious material before Your Lordships. Hence, the statement, even making the statement that there is no evidence, is laughable, Your Lordships. The other aspect, Your Lordships.
Now you are exceeding time.
Yes, your Lordships have stated 3:30, Your Lordships.
No, we
Kindly.
have not stated. We said 5 minutes beyond 3:15. It's already 3:24.
Your Lordships, kindly, Your Lordships. Your Lordships, on page 47, Your Lordships.
This won't register upon us. Please take note.
Yes, Your Lordships.
Anything beyond 3:25 is not registering.
Yes, Your Lordships. Your Lordships,
just give the citation.
Yes, Your Lordships.
And
another important citation is on page 64, Your Lordships. On page 64.
No, serial number.
On page 64, it is at serial number 3. The specific aspects for Your Lordships are on page 75, 77 and 82. The court observed that the state cannot be allowed to change course and belie legitimate expectations, as regularity, predictability, certainty and fairness are necessary concomitants of governmental action. And then at paragraph 27, a state instrumentality seized of the solemn responsibility of making selections to public services must maintain a high standard of probity, transparency, and not expected to remain nebulous as to its norms or resort to falsehoods before the court, contrary to what it had stated in its earlier sworn affidavits. All their affidavits state 4 different things in 4 different affidavits, Your Lordships. This also has been set aside, Your Lordships. All of these exams have been set aside. There is one judgment, Your Lordships, which is not a service judgment, but which is important from the accountability point of view, Your Lordships. This is on page 125, Your Lordships.
Serial number 6.
Yes, Your Lordships. 6 and 5. 6 and 5.
That's all.
Yes, Your Lordships. And the first judgment, Your Lordships. First judgment at page 2. They claim, Your Lordships, they claim that we are non-meritorious, and that's why we are before Your Lordships. Candidates, by agreeing to participate in the selection process, only accepts the prescribed procedure, not the illegality in it. In a situation where a candidate alleges misconstruction of statutory rules and discriminating consequences arising therefrom, the same cannot be condoned merely because a candidate has partaken in it. The constitutional scheme is sacrosanct, and its violation in any manner is impermissible. In fact, a candidate may not have locus to assail the incurable illegality or derogation of the provisions of the Constitution unless she participates in the selection process, Your Lordships. Your Lordships, there is another very beautiful judgment I would like to end with in learned senior Surender's written submissions, Your Lordships. I won't take Your Lordships through it. I'll only take Your Lordships through the judgment. This judgment, Your Lordships, is on page 326, Your Lordships, of the learned seniors written submission compilation. This judgment speaks specifically about at 370, Your Lordships. At page 370, from paragraph 66 to 69, it specifically speaks about malice in law and malice in fact. This judgment specifically states that it is not mass copying, etc., that is required to set aside a selection process. That is malice in fact. It is the systemic changes, it's the systemic violations of the notification, of the deliberate changing of stances of affidavits that the Service Commission follows as a state instrumentality, which is a malice in law that is germane to cancelling the examinations. Hence, merely stating that mass copying is not there. Well, the Service Commission did all the job for us. They did the entire job of changing the notification, changing the rules of the game after the game had begun, about violating annexure 6.1, violating 15.2, 15.3, 12D, 15.5, everything has been changed. And the last aspect is that, Your Lordships, the mistake in law stems from the fact that I cannot take umbrage or I cannot hide behind the rule stating that 311 of the Service Commission rule states that I have residuary powers. The residuary powers only kick in when there is no specific clause relating to how you should proceed, relating to how I should proceed and how you should proceed. If there was nothing relating to biometrics examination, if there was nothing related to the number of hall tickets, or if there was nothing related to the OMR sheets, or if there was nothing related to the evaluation process, then the residuary clause would kick in. It would not kick in violation of the specific rules. Therefore, the residuary rule under 311 is of no use, is my respectful submission, Your Lordships, and the entire process has to be set aside, Your Lordships.
You will start with the reply.
May I, Your Honor? My counsel couldn't appear. She wishes to place her notes before the court.
Which item?
Writ Appeal 1070, Your Honor. Item 120.
Your Lordships, I just wanted to add one point, Your Lordships. I just wanted to bring to Your Lordships notice that the appellants were stating that we are candidates who don't have merit, etc. Your Lordships, two of my writ petitioners and now writ appellants are selected candidates, Your Lordships. I'll give you, Your Lordships, the names also. Your Lordships, Nagaraju is the writ appellant, or rather, apologies, writ petitioner 20th, Your Lordships. He's been selected as MPDO, and Shiva Krishna, the writ petitioner 16. He's been selected as ATO, Assistant Technical Officer. I'm not sure what it stands for. Two of the writ petitioners were in the GRL. There was no selection list. Your Lordships, there was no selection list because it was stayed. The GRL had both writ petitioner 16 as well as writ petitioner 20 at your lordships. They have cleared the certificate verification and now they have been posted as well, your lordships. And they are still respondents in this writ appeal, because they themselves clearly state that this is not the kind of examination through which we want to be admitted into service, your lordships. So the very claim that is made in all service cases, they are not good enough, hence they came to court, falls flat on its face, your lordships, because of the systemic illegalities, the mischief conducted by the Telangana Service Commission, your lordships.
Yes.
Though, my lord, from the hearings of all this, my lord, reply may not be necessary much, my lord. At least that's what I feel. But only to make certain clarifications, my lord. My lord, there was a lot of, my lord, submissions which were made by learned senior counsel Mr. Surendra Rao and others, my lord, on the question that you should not have added that 63 posts, 60 posts, my lord, to the earlier notification. My lord, the earlier notification was for 503, which was, my lord, cancelled, and my lord, 60 posts were added for which the notification is given. I just, my lord, bring those. I just, my lord, those are not that, my lord, could rely on that. My lord, I'm just bringing it to your lordships. My lord, these aspect of this addition of 60 posts to the notification, my lord, the earlier notification of 503, which was cancelled, and my lord, a fresh notification was given wherein, my lord, 60 posts were added. My lord, that was an issue which was raised earlier before this honorable court. That judgment is that, my lord, which I passed on to your lordships. The learned single judge, if my lords will please to see that for once.
Yes.
My lords may kindly take page 20, my lord, of this compilation, page 20. This is the judgment of the learned single judge, my lord. This is Pulla Karthik. My lords may kindly go to page 20. 7D. 7, my lord, is the paragraph which says, my lord, what is an issue before lordships is 7D at page 25. Page 25.
Yes.
Page 20. 7D. It's further contended that notification dated 19/2/2024 is issued with respect to 563 way. As the old notification 4 of 22 was cancelled, withdrawn by the Commission on 19/2/2024, and notification 2 of 2024 dated 19/2/2024 is issued. The candidates who applied for the old notification were also been mandated to apply afresh for the new notification. However, fee payable was waived. Therefore, the candidates who applied for the old notification as well as the new notification have to be treated equally, and as per the recruitment rules, all the eligible candidates have to be treated alike, and there cannot be any discrimination. Answer is at page 30. Page 30, my lord, your lordship will please. Page 30, the answer to this issue.
Yes.
Here it is pertinent to note that relevant events in chronology order dated 2 of 2024 was issued on 19/2. Preliminary note examination was held on 19/9/6. Preliminary key published on 13/6 inviting objection. Last date for submission of objections was 17/6/2024. And WP 21239 of 2024 was filed in the month of August, while the main examination is scheduled on 21/10/2024. As submitted by the parties during the course of argument. Thus, after a lapse of 6 months from the date of cancellation of old notification, the petitioners approached this court without assigning any reasons for delay, much less day-to-day delay. If the petitioners in WP number 2024 are really aggrieved with the cancellation of notification through dated so and so through web note dated 19/2, they ought to have approached this court and challenged the same at the earliest point of time. Though the delay on the part of the petitioner appears to be only 6 months, but in the matter of this nature, the day-to-day delay matters, and further the petitioners failed to even explain even a single reason for the delay in approaching. And my lord, the petition was dismissed. My lords may kindly go to page 54 for once. That's the writ appeal judgment. Out of this single judge judgment, my lord, appeal was filed. My lords, will find it at page 54. It starts. Page 54. It starts. My lords may kindly go to page 73, para 20. Page 73, para 20. A perusal of the notification dated 19/2/2024 makes it clear that the entire schedule of selection was already stated, wherein the preliminary examination was supposed to be held in the month of June, and the mains examination were scheduled to be held in September 20 and October 2024. When once the schedule of selection process has been set out in the notification, the question of postponing the main examination, which is scheduled to be held on 21/10/2024, would arise, and stalling the exam would not arise, and stalling the examination, which is scheduled to be held in just 2 days, would cause more inconvenience to several thousands of students who are likely to attend examination. And this court takes a judicial note of the fact that the Public Service Commission has issued notification way back in 2022. And in spite of several attempts being made to conduct the elections, they have ended up in disputes. And finally, the preliminary examination was conducted in the month of June 2024. And that the next process of selection is conducting main examination, which is scheduled to be held on 21/10. And we are of the considered opinion that this court is not inclined to postpone the main examination, which are scheduled on 21/10 onwards. Insofar as the appellants in writ appeals, they have challenged the notification on the ground that the Telangana Public Service Commission would not have cancelled its earlier notification and issued fresh notification. In this connection, the appellants have participated in the preliminary examination and in the selection process, and also having been unsuccessful in the selection, they cannot turn around and challenge the notification. The appellants are aggrieved by the issuance of fresh note. They should have challenged the notification after the results of the preliminary question are published. They would not have, sorry. Therefore, the judgment so and so relied on Ashok Kumar. My lord, this matter was carried, my lord, to the Honorable Supreme Court. Honorable Supreme Court dismissed it. That is at page 78. My lords, may kindly take page 78. I'm sorry. My lords, may kindly take volume 7, 14, page 1400 for once, my lord. That's a division bench judgment of our own High Court. Volume 7, 1400, my lord. I'll just bring that judgment for your lordship's consideration. A division bench judgment of our own High Court. My lord, 1400, if your lords will please to see. It's a division bench judgment of our own High Court. Volume 7, my lord.
Page
1400, my lord. 1400. It starts, my lord, the division bench judgment.
yes. Yes.
My lords, may kindly take 1417.
Yes.
In WP number 23775, para 3, my lord. Para 3. Dr. Aditya Sondi, learned senior counsel representing Palle Srinivas Reddy, urged that as per the directions contained in the order of this court in WP number so and so and affirmed in WA number so and so, the only option left to the TGPSC was to reconduct the examination. If TGPSC intended to conduct a new examination, appropriate direction should have been taken from the court. In the teeth of the direction of this court to reconduct the preliminary examination, cancellation of an earlier notification number 4 dated 26/4/2022 and issuing new notification number 2 dated 19/2/2024 is bad in law. Secondly, in the event of reconduct of examination, the respondents were required to adhere to the same number of vacancies, whereas pursuant to a new notification number 2 of 2024, they have enhanced the number of vacancies from 502 to 563, thereby enlarge the zone of consideration which is impermissible. This amounts to change of rule of game after commencement of the game. Reliance is placed on the recent constitution bench of so and so. My lords, may kindly go to page 1429, my lord. My lord, 1429, my lord, finding starts at page 20, para 20. 14.
Yes.
Para 23, your lordship, please. 23, my lord. My lords, may kindly see 22 also for once, my lord. 22. A microscopic reading of the prayer made in WP number so and so shows that the petitioner therein prayed for setting aside the second notification number 2 of 2024 dated 19/2 and prayed for restoration of notification number 4 dated 26/4. It was further prayed that issuance of notification number 2 dated 19/2/2024 runs contrary to the directions of this court in WP number so and so. Further direction prayed for was to conduct fresh preliminary examination in pursuance of notification dated so and so. It was prayed that the selection should be confined to 503 vacancies notified in pursuance of the first notification dated 26/4. A prayer to segregate the vacancies was also made. It was also specifically prayed to set aside the second notification dated 19. The writ court by common order dated 15/10/2024 dismissed the WP number so and so by recording the following finding. My lord, this is the finding of the learned single judge which your lordships have seen. Admittedly, this order of the learned single judge was unsuccessfully challenged in writ appeal number 188 and 1190 of 2024, and the division bench of this court, while affirming the order of the writ court, relied upon the judgment of the Supreme Court in the case of Ashok Kumar so and so. Admittedly, SLP was dismissed. But this matter also was carried to the Supreme Court. Your lordships will get it 1444. One four four four, 1444. 1444, my lord, is the Supreme Court judgment. This matter was carried to Supreme Court.
Yes.
Starts at 1444, my lord.
Yes.
My lord, I only like to bring to your lordship's notice, my lords, I pray your lordships to kindly take judicial notice of the fact that a continuous tirade, my lord, a relentless litigation being carried out in order to stall these proceedings and this recruitment. Continuous. Your lordships may kindly please take note of the fact that there were endless writ petitions up to the Supreme Court again and again to stall this recruitment process. On one ground or the other, one ground or the other. Continuous nitpicking. Endless nitpicking. This way, even a class examination of 20 students can be found fault with. My lords may kindly take the judgment of the learned single judge at page 297. This issue, my lord, was decided by the learned single judge, my lord. One issue, my lord, which was decided in favor of the state or the UPSC or the, my lord, Public Service Commission. My lords may kindly take page 297 of the judgment of the learned single judge. My lord, volume 2 may not be necessary, my lord, because it was held in favor of the
Now that we have noted.
Service Commission. My lord, no appeal is filed against that. And endless submissions are being made on that. Page 297, my lord, that G, increasing vacancies by adding new vacancies. Page 297.
Yes.
My lord, if your lordship will please to see, my lord, the learned senior counsel, my lord, Mr. Surendra Rao, brought to your lordship's notice page 217 of our written submissions. My lord, we filed it before your lordships. The proceedings, my lord, of the state, Telangana State Public Service Commission regulations at page 217. My lord, this is in respect of, my lord, the conditions of service of the members themselves. If your lordship will please to see page 217. Since your lordships were following, my lord, of procedure where no interference, my lord, to the councils, so that they end it. My lord, we also did not bring it to your lordship's notice at that time. Your lordship may kindly take 217.
Yes.
My lords will please to see page 217 in exercise of page 217. My lord. In exercise of powers conferred under 318 and proviso to 320D of the Constitution, providing 83 of the Reorganization Act. These regulations may be called the Telangana State Public. This regulation, unless context, commission means so and so, Constitution, member, state government. The commission shall consist of chairmen of such members not exceeding 11 in number overly, my lord, comprising so and so. My lord, these are the composition of the commission and their, my lord, conditions of service. But this has got nothing to do with the examination recruitment process, which your lordship will get at 244.
Why did you bring it on? Why did you bring it on record?
My lord, we wanted to be, that's the whole difficulty, my lord. Wherever we wanted to be transparent, my lord, endless nitpicking is being made there. We wanted to see that all the students, my lord, all the candidates, my lord, are put to rest. They should know that they have been selected in their most right manner. It's a whole booklet, my lord, which was filed, which had this. At page 215, it starts, my lord, it's a booklet. The booklet contains both the starts at 215, my lord. It also has the constitutional provisions in that at one go, my lord. 244, my lord, is the regulations. Your lordships have seen that. 244.
Yes.
But this is in respect of, my lord, the examination and, my lord, the procedure to follow. Your lordship will please to see 247. These are the rules, page 247, my lord, since re-evaluation is not there. 247, my lord, so D. 9D, my lord. This is actually, my lord, it becomes actually 39D, my lord. 3 starts at 245. Rule 3, it's 39D, my lord. Re-evaluation of answer sheets.
Yes.
My lord, D, revaluation of answer sheet shall not be entertained under any circumstances. However, recounting of marks will be considered within 15 days from the date of publication of results. My lord, a second evaluation being done, my lord, in the course of evaluation of the answer sheets. My lord, first examiner and a second examiner. My lord, it is being brought to your lordship's notice that that becomes re-evaluation. How can you do re-evaluation and not ever allow re-evaluation for us? That is one of the argument, my lord, which was put forward by one of the learned senior counsel. I would not, would not name them, my lord. My lord, this D is put against the, my lord, Public Service Commission, saying that you did 2 evaluations, my lord, evaluation 1 and 2. 2 becomes re-evaluation, which you would not have done. So if you have done it, you should allow us to be done. That's a process of evaluation. It's not re-evaluation. An examiner 1 and an examiner 2 or an examiner 3 is a process of evaluation of the answer scripts. It's not re-evaluation. Specific exclusion of re-evaluation not being.
Just trying to understand once again. Say any evaluation, first or second, this evaluation was being done by one of those subject domain experts or
subject domain experts only, my lord.
No, but as it appeared from the submissions,
my lord,
that for each question was any other examiner also marking
no,
it?
The subject experts or, my lord, these assistant professors or deputy professors or professors, my lord, all were taken from government colleges. In the government colleges,
No, we are not on that. Just trying to get a clarification that perhaps from the submissions it appeared that say there are 10 questions covering 2-3 heads of a main subject. Then different examiners are evaluating different subjects.
Yes. Each of the, my lord, your lordship may kindly see the syllabus for once, my lord. Page 383. 383, my lord. I'll just show it from the syllabus, my lord. How the, my lord, the subject experts were chosen to for each of the subject. Volume 3, my lord, page 383. Volume 3, page 383. My lord, the notification my lord, the notification starts at page 358. This is part of the notification. Starts at, lordship may kindly take 383. If your lordship will please to see, my lord, written examination, general English qualifying test is separate, my lord. Only one evaluator, my lord, because that's one single paper. Only one evaluator. My lord, general essay, my lord, if your lordship will please to see, there will be 3 evaluators. It contains contemporary social issues, social problems, issues of economic growth and justice, dynamics of Indian politics, history and cultural heritage, development in science, education and human resources. These are, out of these 6, 3 questions have to be answered by the student. Not all 6, 3. Only 3 out of these 6. This is syllabus which is given. My lord, in the question paper, they have this, my lord, multiple choice. From the 6, they have to answer any 3. And each of the answer carries 50 marks. And my lord, each of the answer, whoever answers that particular answer, my lord, goes to that, my lord, particular lecturer or professor who is well versed in that subject. Sociology, my lord, social sciences, economic growth and justice, economics lecturer will correct it, not anybody else. My lord, and my lord, next also, if you lordship take paper 2, history, culture and geography, 2, my lord, paper 2. My lord, out of these 3, you will have to correct only 2. You will have to answer 2. The student has to answer only 2. You need 2 answers. Only 2 answers. My lord, overall, my lords will please to take, my lord, for paper 2 also. My lord, there are 3, syllabus contains 3 headings. Syllabus has 3 headings. He will have to answer, my lord, in the question paper 2 out of these 3.
In all such paper 2 to 6, same pattern.
My lord, the only paper 1 is 50 marks per answer. All other are 10-10. All other are 10-10. From paper 2 to paper 6 is 10-10 marks per each answer. And my lord, if your lordship will please to see, paper 1, your lordship will have 3 evaluators per student. English 1, my lord, English is single, my lord, because it's English. When it comes to paper 1 general essay, there are 3 evaluators. Then the 3 separate questions, 3 evaluators. Then when you come to paper 2, my lord, you will have to answer 2 questions. Out of these 3, you will have 2 evaluators. My lords, may kindly make note of it, my lord, because I would like to show to your lordships that for each of the candidate, 14 evaluators were there. For each of the candidate. My lord, we will take one candidate, my lord. One candidate writes general essay, he will write 3 answers. 3 evaluators will evaluate 3 of his answers because 3 are, my lord, they are different subjects. So 3 different subject lecturers or professors or assistant professors will, who have that subject, who are teaching that subject or have taught that subject, are the people who have corrected. There are 3 evaluators. When you come to paper 2, my lord, you will have to answer 2 questions. So 2 evaluators have evaluated it, 2 separate evaluators.
Out of the 3 subjects of paper 2, anyone has to answer 2.
2. So there are 2 evaluators.
And they comprise 50 marks each or?
No, my lord, 10 marks each.
10 marks.
You have 15 questions. 10 marks each question, 15 questions.
Per subject?
Per subject. No, they're short answers.
Okay.
The answers also, how many words should be each answer is different.
Paper 2 has maximum 150 marks.
150 marks.
So one subject will have 75 marks?
No, 150 marks. On the right side, if your lordship will please to see. Marks are also given. Maximum marks 150 for 3 questions in paper 1, 150 in paper 2. My lord,
No, that we understand.
well, I'll
But
tell you, my lord.
For example, in paper 2, there are 3 subjects.
3 subjects.
1, 2, 3.
Yeah.
Out of these 3, any candidate can answer 2 of the
2
subjects.
of choice.
So this 150 marks is divided amongst any 2 of these 3 subjects.
2 subjects.
And each subject may have 10 questions or 15 questions, but the marks are equally divided amongst 3 of these three of these subjects.
2 of these. So 2 evaluators will evaluate. My lords will kindly count it.
Now,
First is 3, second is 2 evaluators.
One more question then. Like say for paper 2, the answer sheet will be only one for history and culture of India, history and cultural heritage of Telangana, and geography, or separate answer
No,
sheet?
one answer.
Acha. Then the next question. Then the other examiner, therefore there are 2 examiners. One who examines history and culture of India, the other one examines, say, geography of India and Telangana.
Page number 5. Page number. I'm sorry, my lord. Insofar as I'm my lord instructed. My lord, paper 2, you will have to answer all the 3. All the 3. But since 2 subjects, 1 and 2, if paper 2, 1 and 2 being common, my lord, regarding history, will be 1 evaluator. Geography and of India and Telangana, because a geography subject, another evaluator. So it becomes 2 evaluators here.
So then there would be a one answer sheet in which any 2 of these paper 2 will have to be answered.
Yes.
Then say if the first one of evaluator, barcode, etc., which is being mentioned so many times, these 2 evaluators would be putting their marks as against the relevant question numbers indicated in this table.
Yes, my lord. That table, if your lordship will please to see, it is there, my lord. Page 1022, if your lordship will please to, it relates to paper 2 only, my lord. Paper 2 only. 1022, my lord. It relates to paper 2 only.
102 of
1022, volume 6, my lord. Volume 5, my lord. Sorry.
1022. 1014 or
1022, my lord. I'm sorry.
Very well.
My lords will be paper 2, my lord.
Yes.
This is paper 2, which your lordships have seen just now.
Yes.
Your lordship will come to, my lord, valuation 1. My lord, valuation 1, V1, my lord, will be on the right hand side corner in that one. In the middle, V1, my lord.
G1,
V1, my lord. V1 on the right hand side, sir.
V1.
V1. My lord, this is valuer 1.
Achha. Very well.
This is valuer 1. Valuation 1.
No, but
my lord, section 1, 2, 3, your lordship will please to see. Sections 1, 2, 3.
Yes.
My lord, you'll have to answer all the 3.
That I understand.
1, 2, 3, my lord, questions are from 1 to 15.
We just want to understand as to say paper 2 of a candidate is being evaluated in a central hall wherever these evaluators are sitting. So this paper would be allotted to 2 examiners sitting together?
No, one after the other, my lord.
Very well.
My lord, if your lordship will please to see, history and cultural heritage, my lord, will be corrected by 2 separate evaluators. That is valuer 1 and valuer 2.
If I may just assist the Advocate General on the Honorable Court, that page, my lord, 1022, Your Lordship sees the section 1, section 2, section 3, left
Yes.
side table. My lords would see after my lord the subtotal in that same chart, your lordships would see valuer ID, valuer sign, and the chief examiner sign. My lord's specific question. Now, my lord, in this history and geography, section 1 and section 2 will be evaluated by the same professor who knows history. One is history of India, the other is history of Telangana. A separate evaluator will evaluate section 3, which is geography. So, my lord, if this bunch of papers are sent to valuer 1, valuer 1 will start evaluating, my lord, 1 to 5 in section 1, and then he will give the subtotal. After completing that, he will also sign as valuer ID and signature. He also evaluates section 2. He will complete this remaining section 2. He'll again give his valuer ID and he will sign it below this. Chief examiner will verify at the bottom of the page. After valuer 1 completes section 1 and section 2, this paper in relation to questions 11 to 15 will be sent to the geography evaluator. The geography evaluator, my lord, only evaluates questions 11 to 15, and he will give the marks in relation to 11 to 15. Therefore, my lord, after he evaluates, at section 3 bottom, he will put his ID, he will put his signature. Again, my lord, the chief examiner will verify in terms of a process that we have explained. So this paper becomes complete, where this one paper is evaluated by two different evaluators in respect of different questions. But the learned advocate general will quickly point out to your lordships, in relation to the other subject, there are 3 evaluators for 3 sections. So first section will go to one evaluator. Second section, after the first person completes, my lord, that paper is sent to the second evaluator for the second set, and the third evaluator for the third set. But whoever evaluates will mark only for their questions. They will give this valuer ID and valuer signature. After the full paper is completed, my lord, then your lordship sees after the table in the middle of the page, my lords will find grand total marks. All 3 are combined and the grand total marks are done. My lord, they are also put in words in the next table. My lord, then the scrutinizer ensures and verifies that the marking done, even if it is by one, my lord, some subjects are only one evaluator, but he will verify everything, sometimes by 2 evaluators. He will verify the totaling is correct, the marks put are correct, the grand total is correct, and then he will sign as the signature of the scrutinizer. So this is the process, my lord, that is followed for all of the papers.
Who
And my
fills
lord,
up?
he'll bubble it, my lord. Your lordships will see the grand total marks.
Next 2 columns. Who fills up this grand total marks and marks in words?
My lord, the scrutinizer, the signature of the scrutinizer, my lord, who puts the signature at the bottom, he is made responsible for doing the grand total marks in words. Therefore, he signs below that.
And then these bubbles, who fills?
Bubbling, my lord, take for instance, my lord, this gentleman has got 120 marks, my lord, the total marks. Here, my lord, the bubbling will be 120. Grand total, my lord, this bubbling total, grand total marks, 120, he'll bubble it.
So why there are so many bubbles?
My lord, 120. On the right side, my lord, on the right side, my lord, you will please to see it is serial number of answer booklet in the bundle. That is not marks, my lord. Each, there are 40 answer sheets in each bundle. Actually 40 answer sheets. My lord, when they actually wanted to do the examination, they wanted to make each bundle 50. That's it.
One correct. I just took further instructions. My lords asked a specific question: who does the grand total marks? The last of the evaluators, because he puts his marks, Lord, he puts the grand total marks by combining the 3. This is re-verified, my lord, by the scrutinizer, who then signs at the bottom of that page. I had mentioned that the scrutinizer does the grand total marks. It is the last evaluator. I've just taken instructions, not because officers are present in the courthouse.
Very well. And how these bubbles are filled up?
But that 50 bubbles are, my lord, actually, my lord, each answer, my lord, they are about, my lord, 30,000, my lord, 30,000 are the candidates, my lord. One subject, my lord, will be, each of the subject answer books will be 40 answer books in one bundle. Initially, they wanted to do it 50, but they reduced it to 40 so that, my lord, for convenience sake. And, my lord, if the answer booklet is 20, my lord, it's 20. This bubbling will be answer booklet number 20. This is only for booklet answers.
Where is this booklet answer?
Number of answer booklet in the bundle, your lordship, on the right side. Lordships have seen grand total marks bubbling.
Out of 40 in that bundle, The serial number of that answer booklet will
If it
be
is
indicated
2020,
here.
he'll mark, that's all. Nothing to do with the marks.
And after this exercise is done, then there is again
No.
matching of that bar coding.
Yes, last.
This is torn, then it is again
Same for
tallied
second
with the
Second,
barcode.
next, your V2, your lordship. V2. Same thing. V2.
Maloj, I'm sorry to interrupt, but each answer paper has a 6-digit number on it. I have a answer paper here with me, a question paper. For example, if the number is 226229, if you see that bubbles, there are 6 columns of bubbles. 6 columns of bubbles and 10 rows. So you have to shade those. It's not very clear, I think, in the printout, but those bubbles have the numbers 0, 1, 2, 3, 4, 5, 6, 7, 8, 9 vertically going down. So you shade 2, then you shade 2 in the next column, then you shade 6, then you shade 2, so that the serial number can be read electronically. Because each booklet has a 6-digit number.
These evaluations were held in a centralized place or distributed over several.
No, centralized. All of them were there in the Murray Chenna Reddy Institute. There's a very big institute, which is administrative. All the administrators are trained there. State and some of the center IAS guys also get to them there. They were there for a whole month. All the there's provision for stay for all the evaluators. A little above a month, they were all there. Ballot.
Yes, and
This 383, if my lords will please to take for once. My lord, paper 2 is corrected by two subject experts. My lord, paper 3 by 3 people, because it's 3 different subjects by 3 people. 383, my lord.
Yes.
Paper 3 by 3 people. Paper 4 is by one subject expert only, because it's all regarding economy. Paper 4. My lord, paper 5 is by 3 people, my lord, because there are 3 subject experts. 3 different subjects, you need 3 subject experts. Then, my lord, paper 4, because paper 6, my lord, I'm sorry. Paper 6 is by one expert, because all the 3 are related subjects. Therefore, my lord, if I will count for your lordships from English onwards, my lord, it becomes 14 evaluators. For each candidate, his papers are evaluated by 14 different evaluators. 14 one set and then 14 the second evaluator. But
Now about the third evaluator in cases of difference in 15%. 15% or more.
15% or more.
So this third evaluator doesn't have to do bubbling.
No.
He simply gives the marks. But in case there are more than one evaluator, like say in paper 2, which you pointed out,
Yes.
then the third evaluator also means that there are 2 evaluators for third evaluation.
In the event, my lord, it's more than 15%, third evaluator.
No.
Therefore,
In the third evaluators exercise also, say for paper 2,
yes.
if a candidate has answered history and culture of India and geography,
Yes.
so then there will be 2, 3 third evaluators.
In the event of difference, my lord, there will be a third evaluator for each of the subjects.
Each of the subjects. And in that case, this whole argument about matching of the barcode for the evaluation done by third evaluator, is it also done or simply?
My lord, there is, my lord, if your lordship will please to see the answer sheet, my lord, there is one barcode in the left, my lord.
That
in
we
the left
have
corner, my lord, here.
That we see.
That is there, my lord, always, my lord, with the answer sheet. With the answer sheet. One and, my lord, 1, 2, 3, my lord, these 1, 2, 3, all are toned. One will be toned, my lord, saved. 2, my lord, for the purpose of first evaluation and second evaluation. My lord, both of them will be put into the computer. If it's more than 15%, my lord, it will say more than 15%, it will go to the, my lord, third evaluation. And third evaluation arose, my lord, only in respect of 5,584, my lord, which comes 5,558 papers, not in respect of 558 candidates. It arose, my lord, in respect of 5,558 out of 1.5 lakh answer sheets. So it was about 3%, my lord, that this issue arose to the third evaluator. And my lord, this barcode, my lord, on the left is there, always there. And my lord, your lordships have seen, my lord, 14 evaluators are there.
Very good.
Trying to say, my lord, something went wrong in respect of a candidate cannot be for 14 different evaluators.
So the third evaluators, this second page 1024, this remains with the answer sheet.
Yes.
And this remains with the barcode on the left hand side of the first.
Yes.
So there need not be any matching when the third evaluator has evaluated.
Not necessary.
That's the
argument.
answer. Now this answer sheet, whenever it is supplied to a candidate taking any of these papers, these first two pages of the answer sheet are there containing these barcodes, third evaluator in every such answer sheet.
Every answer.
There was an argument that this second page was introduced later on in the web note, and said that this is an afterthought, that the first page only was evidenced in one of the web notes.
Every answer sheet has all these things.
So every candidate who takes a paper sees the page 1, page 2, wherever his column has to be filled up, signature, etc., he fills up and then proceeds to the third page onwards to answer the question.
That's every answer sheet. There's no two ways about it. And my lord, providing for a third evaluator, my lord, you cannot find fault with it, my lord. And my lord, in respect of 14 subjects, 14 evaluators, my lord, 14 different subjects, 14 evaluators. What a, my lord, to do anything, my lord, would be beyond any imagination. 14 evaluators for each of the candidates.
Now, this statement, is it reflected from any of the affidavits that a candidate's paper are being examined by 14 evaluators? Because
my lord, we said, my lord, that each of the answer sheet, my lord, each of them, my lord, answer are given to a expert.
no, because for
if there is a pleading in an affidavit, my lord, if there is a pleading in the affidavit, you can give an answer. There is no pleading to this effect. Only to clarify to your lordships, this is being given to my lords.
Very well. So, what we want for our understanding, that on a few sheet of paper, how this filling up of this and first page of the answer sheet is being done, that you need to give it to us by tomorrow itself.
Tomorrow.
Whatever has been stated
Tomorrow.
as to how two examiners, then how scrutinizer, etc., etc.
Will be explained to the last word.
That is explained to us.
Bring it to your lordships tomorrow. Though, my lord, in the absence of a pleading, my lord, it was not there in the answer. Your lordship, since they raised it, your lordships are putting query, my lord, we'll answer it to your lordships. Next is the
any other issue which you want to reply, or
my lord, learned senior counsel Mr. B. Adinarayan Rao, my lord, spoke about, my lord, preliminary notification and normalization. If my lords will please to take page 358.
that is the last page of that.
358, if your lords will please.
Yes, 350.
The notification. My lord, 359, my lords will please to see. The learned senior counsel brought to your lordship's notice 1.7. 1.7. The commission will normalize the scores of candidates for the computer-based test, which are conducted in multi-sessions to take into account of any variation in the question papers across different sessions. The criteria of normalization is given in Annexure 7. My lord, pausing here, my lord, this was for the purpose of preliminary exam. This is not for the main examination. Preliminary examination, since, my lord, about 3 lakh candidates came, my lord, the initial thought at the time when notification was given, my lord, they wanted to do it in about 4 to 5 sessions. About 10 sessions, my lord, they wanted to do it. Distribute the candidates and then do it in 10 sessions. My lord, for 10 sessions, you need 10 different question papers. Therefore, they thought normalization would be done.
This whole process of 2 examiners and third examiner, this was inherent in the answer sheet from very beginning, this
Every
concept.
answer sheet, my lord, we'll pass on the answer, one of the answer sheet also tomorrow for your lordship's consideration. Each and when there is no dispute to that. It's not in dispute that they don't have it.
The affidavits of the Public Service Commission have one after the other tried to explain it or improve the statements made one after the other. First, it was that there is no moderation, scaling, etc. Then it was again changed by another affidavit. So therefore, it is necessary to know that from the start, whether this whole idea of evaluation by way of these 2 and third was there in existence, or it took place during course of the
No, no, it was there.
Since this argument, when it was made, if I may just assist your lordships, the argument my learned friend Rachna Reddy made was in the first draft answer sheets that were published in August, the third evaluator was not there. She said, but by September they introduced the third evaluator. But the exams were conducted in the month of October. So my instructions are in August itself it was shown, but on demurrer, even according to their arguments, 1 month prior to the exam, specific to the question my lords are putting. By September, they say they had a visibility of the answer sheet, including the third evaluator. So much before they went to the exam, my lord, they knew about this third evaluation also.
But this third evaluator was always there, my lord.
Yes.
My lord, page 359, my lord, overleaf. This one, my lord, was in respect of a preliminary test, my lord, which was to be distributed among about 10, my lord, 10 schedules for 10 schedules for different candidates for 10 sessions. One, my lord. But that was not done, my lord. Examination was conducted once only for across. Because if the question paper changes, then normalizations need to be done. Since the question papers did not change, it was one single question paper, and that too for preliminary examination. It's not for mains. My lord, 1.8, your lordship will please to see in the same thing. Main examination would be, my lord, this is for prelims. Main examination would be in descriptive type. The commission reserves the right to conduct the main examination either through digital mode of question paper, display, or conventional hard copy based question paper. 10 also, 1.10 also. Option of the medium for writing the preliminary test, objective test, and main examination conventional type. My lord, main examination was always conventional. Will be taken from the candidates in the application form itself. For 1.7 is annexure 7, my lord, at page 407. For 1.7. 1.7 was never put in use because it was one single preliminary examination. Therefore, my lord, annexure 7 was not used.
This clause 15.2 issue,
Yes. Yes.
this if you could explain it in your
My
own
lord,
way.
15.2. 15.2, my lord, may kindly take 15.1. The marks secured, the 377. The marks secured in the preliminary test will not be counted for ranking. The marks in the preliminary test will not be notified as it is a screening test. The marks list of the main examination, total marks of all the candidates will be displayed on the commission's website. However, paper-wise memorandum of marks of all candidates can be accessed in their respective logins for a period of 1 week. My lord, there is no dispute from the candidates, any of the writ petitioners, that their login marks were not given to them. Their login marks were given to them. Then comes, my lord, 15.3, where, my lord, 15 days was given for them, my lord, to apply for re-examination.
No, on 15.2, as per what has been contended, the provisional mark sheet of all the candidates was required to be displayed on the website of the commission, and individual candidates had the option or the opportunity to access through the password ID, etc., their own marks. These two were the requirement of 15.2, or only individual candidates did have the option?
In 15.2, my lord, the individual marks of each of the candidate, my lord, which was, each of them had a login and a password, each candidate. My lord, in their login and their password, they will find their total marks. My lord, their marks in each subject, not even total. We have shown to your lordship.
That we remember.
The total is not given. Each of the individual marks in each of the answer sheet is given to them. Answer, my lord, is given to them. They have an option to apply for, my lord, recounting within 15 days, which many of them have done. My lord, recounting was done. After the recounting, my lord, totaling is done. and the marks list, my lord, is exhibition. Page 435, lordship.
So under 15.2, there is no general publication of the provisional marks list of all the candidates?
No, my lord, it was not done. It will not be done also. And, my lord, they are trying to tell, my lords, my lord, for the purpose of, my lord, applying for recounting, they need to know the marks of somebody else, my lord, would not apply to reason also. They will have to plead what's the prejudice that is caused to them.
No, that we understand.
Neither prejudice is pleaded, nor prejudice is, my lord, they will have to demonstrate it. That's what the Supreme Court said, my lord. I bring that one paragraph for your lordship's consideration of the Supreme Court. You will have to plead prejudice. You will have to demonstrate prejudice. None of that thing is done. 15.2, my lord, there are two sections to 15.2. One is, my lord, you will have to give individual marks in their logins, which was done. And, my lord, 15.2 doesn't say, my lord, the marks list of the main examination, total marks of all the candidates will be displayed on the commission. It doesn't say provisional marks.
So the understanding on behalf of the commission is that as per clause 15.2, every candidate has access to his own mark sheet through his UID and password.
Yes.
But the commission's website doesn't display the complete marks of 2,000 or 21,000.
Provisional marks.
Provisional marks?
No.
Okay. After the recounting exercise, if any, is done, then that list is uploaded.
Then the marks are totals of each of the candidates, and that is displayed at page 435. That is what is shown. On 30th March, my lord, the total marks were displayed.
Yes.
My lord, 435.
Your page 449 of volume 3.
Yes.
Or page 451.
Yes.
Has this marks in decimals.
Yes.
How is it shown in 1018 at OMR?
We have no inclination as to how the marks are shown, your lordships, because the highest marks they have shown as in decimals, but the fact of there being 14 evaluators for one answer script is itself
Evaluators we will come to, but I was only trying to understand how these decimals are shown, because
allegedly there are 3 evaluations.
The knowledge that I have, as far as OMR sheets and competitive exams are concerned,
they have to be rounded off.
They have to be rounded off.
They have to be rounded off. But the press note and the web note shows marks in decimals.
Well, just bring it to your lordship's notice, my lord. How, my lord, decimals were, my lord, taken care of, either, my lord.
Your lordships, if I may make any clarifications to I just have two clarifications to make, your lordships. With your lordships permission, I'll just make those two clarifications. Your lordships, as 15.2 is concerned, there was also a concomitant web note dated 5/3/2025 in my IA3. I've included it at page 88, your lordships. 15.2 has to be read in consonance with the web note dated 5/3/2025. It clearly states, your lordships, in the web note. It's there on page 88 of IA3 of writ appeal 1066. The group 1 selection, I'm reading the second paragraph, your lordships. The group 1 aspirants are hereby advised not to believe such false propaganda, etc. The candidates can be rest assured that no injustice will be done to any candidate, and the results are being processed in a fair, transparent manner. The group 1 selection process is being expedited, and commission aims at zero error result. The commission is contemplating to release paper-wise marks in candidate login and also to publish provisional marks list on commission's website very shortly. It's page 88 of the IA3, your lordships. It is exactly in tandem with 15.2. 15.2 clearly states.
Please don't start the argument, because we are trying to clear our own doubts.
Yes, your
We have
lordships,
heard
that
everything.
one. And the other
This
clarification.
Will bring it to your lordship.
So far as the Telugu and Urdu medium are concerned, how many candidates appeared, whether 5 or even 500? The Telugu medium evaluators evaluated all those other papers also written in Telugu.
Yes, sir.
So their experts were there who knew Telugu in even an economy subject or a geography subject.
All these, my lord, these experts, these, my lord, evaluators are, my lord, lecturers and professors who are teaching, my lord, in degree colleges. In degree colleges, the lecturer, my lord, teaches both the languages, Hindi and English and, my lord, Telugu.
In the government of state of Telangana.
In the, my lord, in the degree colleges.
And
But
what,
only at the university level, my lord, they teach in one subject, only in English.
and
In degree, my lord, it's both English and Telugu.
And what about Urdu?
Urdu, my lord, is another professors, my lord, who teach only in Urdu.
So
Urdu evaluators are totally different.
So in that case, whether the persons who are teaching Urdu as a medium, are they also experts in the other papers also?
My lord, Urdu lecturers, Urdu professors are there in each of the subjects. Each of the subjects. History, geography, they teach each and every subject.
All those paper 2 to paper 6 or 7.
Each subject, my lord, each subject Urdu professors are
there are experts who teach and correct in Urdu also.
And my friend, my lord, Lakshmi Narasimha's my lord, client who's filed the appeal, my lord, she qualified in Urdu only. She got selected in
Achha, one more thing which was coming to our mind. Does the mechanism, is the mechanism there in the commission for any candidate to inspect his answer books under RTI?
No.
Nobody has applied also?
No, nobody has applied. At least
just get that information also.
We'll get question of any showing any paper, my lord, I will bring that also to your lordship.
No, we may see, we may not see, but whether a candidate under any mechanism or RTI is entitled to have his own paper inspected by him in the commission's office.
Such thing, my lord, only in the event a court orders, my lord, such a thing, my lord, we can show it to the court or, my lord, to the candidate. And that happened in one of the papers.
One such matter, the candidate did not qualify in English.
But you filed a writ petition saying that I want to see my answer script. So the learned that help revaluation is impermissible. But allow him to see his answer script so that he is sure that he did qualify. But not under any law, but that was a writ petition under 226. High Court directed.
So none of these writ petitioners have inspected their own answer sheets.
There is no request.
So they are not saying, any one of them, that their paper has not at all been evaluated.
No, none of them are saying that.
It is nobody's case. This decimal melody, may I just answer?
Yes, yes.
The decimal melody is average melody of all the three evaluations. Because melody evaluation, whatever is done melody, the highest mark is given in decimal. So melody, what is bubbled there is only the marks which are given melody, not a decimal. The decimal comes at the average. Average is taken.
It is not in decimal, but the page 432, if I recollect rightly.
Highest marks are given. So highest marks could be average melody of all three. So average of all three could end up in decimal.
No. The average, it's not the average, it is
explain.
paper wise highest that is given.
No, paper wise meaning the after evaluation. Two closest, yes, I stand corrected.
But if I may just explain.
It is
Suppose
page 451.
in one of the papers, one evaluator gives 80 marks. No half marks are given, my lots are completely right. The second evaluator gives 100 marks out of 150. Now the variation melody is more than 15%. It is then sent to the third evaluator. If the third evaluator in the hypothetical example I'm mentioning gives 97, then we have to take the average of the two closest evaluators. So the 3 marks are 80, 97 and 100. So the two closest are 97 and 100. The average of the two is determined as the marks of the candidate, which becomes 98.5. Otherwise, each of the three evaluators does not give 0.5. Yes, it's the average.
This decimal arises first time if the third evaluator is involved. So that's the reason perhaps there's no bubbling. We do not know.
No,
but even first and second. 197. If the two evaluators give that many marks, we have to take the average. So 98.5 becomes the marks even in the first round of evaluation.
So this all you give us in a piece of paper, because these are the finer niceties of how actually it has been worked out. So we close.
Your Lordship, just two clarifications.
Sorry. Regarding that point,
I'll request for 5 minutes after the Advocate General only to supplement one or two points.
Yes.
There is one matter, my lord, which it was brought to your lordship's notice at page 310, my lord, which the learned single judge, running page 310. Page 309, my lord.
Yes.
The observations, my lords have got. The observations of the court about the sealed cover information. My lord, it was, my lord, the learned single judge said, give these things in a sealed cover. My lord, it was given there. But my lord, it is now, my lord, part of the judgment. The observations of the court about the sealed cover information are as follows. My lord, what was being brought to your lordship notice on a continuous basis, my lord, overleaf at 310. How is it different in different answer sheets? The key is different. How the awarding of marks. Firstly, in some instructions, 5, my lord. Firstly, in some instructions were given to the evaluators for grading such as 0 to 9 very poor, 10 to 19 poor, 20 to 29 good, 30 to 39 very good, and 40 and above is excellent. These, my lord, relates to that 50, my lord, page paper 1, my lord, where each of the answer carries 50 marks. My lords, I have shown the syllabus for your lordship's consideration. Paper 1, general essay, you will have to write 3 answers 3 answers, each of the answer carries 50 marks. How to grade it? Well, what is brought to your lordship's notice? It is different.
383.
383. 383. My lord, paper 1, my lord, general essay, your lordship will please to see. You will have to answer 3 answers, my lord. Each of the answer carries 50 marks. My lord, this is sort of an indication which is given to the, my lord, evaluators that in the event he is very poor, you give them 0 to 9 marks. 10 to 19 poor, 20 to 29 good, 30 to 39 good, and then 40 and above is excellent. Then secondly, my lord, if your lordship will please to see 310. Secondly, in para 5. Secondly, some keys given other grading 0 to 2 very poor, 3 to 4 poor, 5 to 6 good, and 7 very good, and above 8 is outstanding. This is in respect of 10 marks answers. Well, these are for the experts. These keys are given for the experts, for the subject experts, people who evaluate on a day-to-day basis, not for the purpose of for us to evaluate all that. Not court cannot never be an expert. There is no prevarication or anything over there.
Yes.
My lord, learned senior counsel, my lord, Mr. Dama Sheshadri Naidu, my lord, brought to your lordship's notice page 454 of this, my lord, book itself. My lord, volume 3, page 454. My lord, this was filed, my lord, by the petitioners themselves, not by us.
454 is Proceedings of the Commissioner of Collegiate Education.
Yes, this was produced, my lord, by the petitioners. My lord, we have brought to your lordship's notice many a confidential papers of this nature, my lord, were produced, my lord, by the petitioners. My lord, this is in respect of, my lord, evaluators at page 455, overleaf, my lord, page 455. Each of the, my lord, subject experts and all.
Your lordships, may I make 2 clarifications, your lordships, less than a
Please,
minute.
My friend
they
will
have
take over.
their
Just 2 or 3 quick
Now,
submissions.
there's one judgment, my lord, not that I'll read it for your lordships. We'll just pass it on. 2010 5 SCC page 349. My lord, endless nitpicking is made. My lord, they did not show to your lordships what's the prejudice. My lord, 2010 5 SCC page 349. Para 89 and 92, my lord, 92 last. Para 89 and 92. My lord, it only says, my lord, this is what it is. My lord, though it is, my lord, a service law, in the latter, prejudice normally, my lord, it only says, my lord, para 92 last, if your lordship will please to see. Last 3 lines.
yes.
Prejudice normally would be a matter of fact, and a fact must be pleaded and shown by cogent documentation to be true. Once these basic feature lacks, the appellant may not be able to persuade the court to interfere with the departmental inquiry or set aside the orders of punishment. Prejudice, my lord, no matter in what case, my lord, you will have to plead, demonstrate before your lordship. Nothing of that sort is done. Obliged, my lord. Your lordship may allow
There-
the interpret, my lord, unless nitpicking acceptable.
There is no specific categorical assertion against any of the selected candidates
No,
that he got selected because of.
no, no.
None,
And
none.
no, my lord, as your lordships were initially asking also, my lord, no question of any mass copying or anything, my lord.
They have not made parties, but they have to implement them.
We have got implicated in all those.
Yes, Mr. Reddy, you want to
Yes,
say something?
three broad contextual hooks. Your lordships may not specifically ask this question. But first, that there are no allegations of malafidis in any of these matters.
Yes.
But second, your lordships may not are not concerned with allegations of any paper leakage.
Yes.
Third, there are no allegations of any specific examination center being compromised. That certain undue favors, there was either lack of invigilation or my lord, certain candidates who appeared from one particular 18 and 19 I will deal with separately, women candidates, but no allegations that the examination center was compromised or candidates were helped with unfair means to write an exam. All these allegations are absent. With these three contextual hooks, my lord, your lordships have set the standard very clearly that in a writ jurisdiction, when your lordships are considering, my lord, any challenges, your lordships, my lord, would look at it from the broad parameters of judicial review, giving due deference. But this would not be the exercise, my lord, like they tried to make of. My lord, I was going to use the word nitpicking, but I think the learned advocate general improved it, calling it continued nitpicking. But your lordships would not exercise the ordinary jurisdiction of a patent examiner to see if this is right, that is right, this is right, my lord, in minute detail. Your lordships would be on the broad issues to see if anything that is systemically affecting the examination and the results, my lord, something that shocks the conscience of the court. My lord, the Vanshika Yadav test.
That's what.
So, my lord, if your lordship sees, while they make allegations, my lord, that examination centers went from 45 to 46, they have not been able to establish what is the prejudice caused by having one more center to help PWD candidates. Women candidates allotted to 3 centers, 3 women colleges, only women candidates allotted. But they have to build upon that. They have to say what flows from such women candidates being allotted to that center. I've already placed the chart to show to your lordships that the candidates were selected because the number was large. There were 700 and 800 candidates who were appearing. Percentage remained 5 only. The number would seem larger out of the total number. The mass pool is larger, the selected candidates become larger. So I've placed that chart. And I've shown your lordships 18 and 19, my lord, are at serial number 3 and serial number 13 in the list of successful percentages of centers. But yesterday, my lord, one chart was produced for the first time showing red line and green line. My lord, we hear of gerrymandering, my lord, in elections. Your lordship sees Moinabad, which is at the south, they draw the line from the south, go to the north and come down to say that this is the north. Because otherwise, if what is south, Moinabad is added in the south, the percentages changes. So they had to make it startling. In any event, my lord, this is not pleaded, not placed before the learned single judge. My lord, given across the board for the purpose of an argument. But just one last aspect I need to touch. My lord, that is an argument relating to moderation, lack of moderation. My lord, they tried to say that what we did was averaging. It is not moderation. My lord, page 955, lordship just notes it. What I am doing, my lord, is I am giving one 6-pager note. Every argument answered, my lord, with precise detail with regard to what is incorrect. But just for your lordship to have a quick idea. Lord, moderation, there is a systemic moderation built in. In terms of, my lord, His Lordship Justice Ravindran's judgment in Sanjay's case, what happened, my lord, in page 955 to 957 of the affidavit filed, my lord, we have specifically explained. After the exams were conducted, that, my lord, the main examiners called all the people who would be evaluating. They were schooled in what they need to do for the purpose of marking, so that, my lord, there is no variation. My lord, we wanted to avoid this hawk and dove syndrome. We have given full details, my lord, in that as to how, after they were trained, my lord, answer keys were prepared, saying that in relation to questions, what would be the pointers on which marks would be awarded. Mock examinations were undertaken, where they mock evaluations, where the chief examiner saw and he undertook a corrective course of action. Wherever he found a dove, told them, my lord, to come into alignment with what would be the preferred, my lord, average method. Wherever there was a hawk, he was brought back in. All of this happened, my lord, prior to the marking itself being undertaken. And after, my lord, the evaluation started, your lordships have been taken through this 2 evaluators for every candidate. So, my lord, there were 14 set of evaluators for 7 papers for 1 candidate, another 14 set in the second evaluation. So, my lord, there are 28 evaluators evaluating a paper, which provides by itself, right? If it is 1 evaluator and second evaluator, there is a larger scope of hawk and dove playing out. But it's very unlikely, my lord, in the mathematic probabilities, that 14 people will be hawk and 14 people will be dove, or there can be 14 people who are hawk and 14 people again hawk or dove, whichever way. So in the very system, the way it works, my lord, the number of evaluators brings in a rationality. We cut out, my lord, these extremes that otherwise would arise if there are only 1 evaluator in first round and second evaluator in second round. The averaging method, one of the councils argued that this is a method unknown, he has not found a parallel. My lord, there is one judgment of our Honorable High Court in relation to MBBS, identical mechanism. My lord, 2 evaluations, more than 15% will be sent to the third evaluator. The closest to average will be taken is the method we follow in this state for MBBS examinations, upheld by this honorable court, saying that this complies with the Sanjay test, Sanjay judgments test, and this is moderation. My lord, that judgment, I'm just placing it. But another important aspect for your lordships, not because this was argued that there is no parallel, I'm placing it only in reply, I could not place it earlier. But this deals with an MBBS exam. But it's a part of my note. My lordship just notes it. It will be in my 6-page note that I'm giving. But separately, in my note that I'm placing, my lord, there is a Madras High Court judgment, which refers to one commission being appointed, my lord, in an earlier instance by one Mr. Ramalingam, my lord, who is one of the respected Public Service Commission members of Tamil Nadu. 1994, a commission recommended this, that there should be 2 evaluators. More than 15% should go to the third evaluator. From 1994, the Madras, my lord, the Tamil Nadu Public Service Commission is uniformly following this practice. Borne out, my lord, by the judgment of the Madras High Court that I am placing. It's a part of my note, my lord. My lord, we actually improved upon the Sanjay judgment which provides for moderation, because, my lord, if your lordship sees para 23, and which is going to be a part of my note, my lord, the Honorable Supreme Court recommended that the examiner must pick up certain papers at random for the purpose of assisting, my lord, for the purpose of checking that there is no variation. My lord, in our affidavit filed from page 955, which I am also capturing in the note, my lord, we have given a full detail where, instead of it being a random check which can happen after the entire evaluation is complete, there was a continuous monitoring done, my lord, by the chief evaluator, who was a part of the process. He was picking out 3 papers out of every bundle of 40 papers at random, for the purpose of seeing that the evaluation by the first evaluator or the second evaluator, my lord, are in line with what was generally practiced, or what was generally schooled in terms of what they need to practice. But all of these details are a part of the affidavit, page 955. And an external check is the third evaluation. So, my lord, my respectful submission is the judgment of the Honorable Supreme Court completely complied with spirit in terms of having moderation. Moderation effected fully. my lord, my respectful submission is, my lord, just to my lord, reiterate what the learned advocate general argued, my lord, that this cannot be, my lord, an exercise where petitioners come and suggest to the court as to what are the better methods of conducting an examination. Your lordships have said this would be left to the, my lord, the wisdom of the constitutional body and expert. Deeply grateful.
My lords, if I may just supplement for 2 minutes, just briefly, just 2 or 3 points which have been made by the counsels for the respondents. Broadly, I want to address this, my lords. One, this is an appeal
Gopal, just 1 minute. Just 1 minute.
Yes.
But I have placed, my lord, my 6-pager note on the contentions, all the main contentions, and my lord, our reply to each of the contentions.
It summarizes all their arguments.
Yes, summarizes the arguments and tries to, my lord, dismantle them to the extent.
Your lordship, may I make just 3 clarifications, your lordship.
But just
Yes.
a minute, let Mr. Gopal Sankar know.
My lords, I'll just be very brief. My lords, the court has been extremely patient in hearing all of us in what is appeal jurisdiction from a single judge's judgment. It was my understanding that we are addressing you as appellants and those supporting the appellants only on the points which a single judge has dealt with and which the writ court has had the opportunity to address. Now, many of the arguments which have been made with compilations and documents, etc., are being handed up and being taken off the cuff. And many of those are extremely technical. They're hair-splitting exercises which are being taken up for the first time suddenly here. I don't think, my lords, the appeal court should be drawn into that kind of verdicts to be delivered on issues which were never addressed earlier. The second, my lords, as a constitutional court, your lordships are being asked to look at a public examination and see what might be the foibles in that which are being addressed by the writ petitioners. In this, my lords, there are 2 aspects which arise in this case. One is of transparency and the other is of moderation. As far as transparency is concerned, my lords, the steps that have been taken by the Telangana Public Service Commission and at every stage them putting out web notes and explanations regarding the steps they are taking has rendered them vulnerable to the very attacks which have been made by the writ petitioners. Having said that, if your lordships were to compare, and this is what the writ petitioners could have brought, but they couldn't bring it because it doesn't exist. And if you were to compare this with the UPSC, with the CBSC, with the NEET, none of them carry this detail of who are the evaluators, what is the types of evaluations, etc. Nobody does this. The fact that Telangana does this has been the reason why there have been attacks leveled against it. It is not enjoined on them either by a law or by a rule for them to give these kind of details upfront. As far as moderation is concerned, I adopt Mr. Reddy's arguments just now. Your lordships will recall that when Mr. Shadan Farasat was arguing, he had said that he and his team had done a survey of nearly 70 cases of the constitutional courts. And this system of moderation of having a first evaluator, a second evaluator, and a difference of 15 had not been looked at. Mr. Reddy is absolutely right. Your lordships, on the 27th of February this year, in Mogli Kinnera of a division bench, has rendered a judgment on this. There are 2 division bench judgments of the Madras High Court upholding the Tamil Nadu Public Service Commission using the exact same system of evaluation in every single one of their public service exams, every single one. The division bench in para 17 and 18 of the Public Service Commission versus Aruna on the 1st of December 2022 went into this very evaluation system, where some parts by evaluator 1, then again by evaluator 2, then if it's a difference of 15%, they look at where it's the closest. And they said this is unexceptionable. There can be no fault found with this. These are 2 judgments, one of 1st of November 2022 in E. Ranjit, and then of 1st of December 2022 in Aruna. And both of them hold the field. It's a position that if one public service commission has been following this in the country, it wouldn't be appropriate, in my view, my lords, when there is no fault found in that system, for just because they are citing that there is such a system, that there is something wrong in it, when you have constitutional courts having upheld it. So there are 3 judgments of 3 division benches, one of which is your own, As far as the cases which were cited, my lords, your lordships have gone through all of that. Most of them can be distinguished on facts. We don't have time, so I'll give your lordships a note regarding that. One thing I wanted to point out is the diagrams that were shown to you. One today, the one which is red and green, and the other one yesterday, are both extremely faulty. If your lordships were to divide the Hyderabad urban area, instead of north and south, if you divided west and east, you will find that the ratio is actually 50% to 50%. It's almost exactly the same. In any case, the system of moderation, and this is, I think, the substratum of how to attack that. The system of moderation has nothing to do with the, I'm sorry.
Yes.
Yes, the system of moderation has nothing to do with the number of people who may have succeeded in a particular center as somebody as some other center where you didn't have that success rate. Let's presume there is that. System of moderation is just to ensure that the vagaries of two different examiners are reconciled. That's all it is for. So this argument that in some centers you had higher success rates, others you had no success rate, has no basis at all. There is not a single judgment which has said that in such a scenario you have to apply or invoke a moderation system, my lords. I only want to say that your lordship this is in our compilation, but the judgment of the Supreme Court in Run Vijay Singh, this is 2018, 2 SCC 357, Run Vijay Singh, sets down in para 30 the principles on which, if there is a re-evaluation to be done, what are the 5 principles that a court needs to follow? The Supreme Court says that if a statute, rule, or regulation governing an examination permits re-evaluation of the answer sheet or scrutiny as a matter of right, then the authority conducting the exam may permit it. If such a rule doesn't exist, then the revaluation or scrutiny of an answer sheet, as distinct from prohibiting it, then the court may permit revaluation or scrutiny only if it is demonstrated very clearly without any inferential process of reasoning or by a process of rationalization, and only in rare or exceptional cases that a material error has been committed. We still don't have this material error. Nothing has been shown that a material error has been committed by the Telangana Public Service Commission in finally having an evaluation the way they've had it. Far from any exam leak, malfeasance, as my friend said earlier this afternoon, nothing has been alleged or found. Until they allege and prove it, there is no question, my lords, of inviting the Constitutional Court into this. I'm very grateful for the very patient time your lordships have taken. Lord, there are 3 brief notes. I suspect my instructing solicitor would have made it much less than brief, but if that can be handed up to your lordships, I'm very grateful once again, my lords. Most grateful.
Your lordships, I'll just take 3 clarifications, your lordships. Your lordships, the fact about just 3 clarifications, your lordships, hesitate a minute. Your lordships, the fact about moderation was being browbeated by every council, your lordships. In fact, it is the fact of moderation or moderation that the learned single judge has passed his orders on, your lordships. At page 940, your lordships, page 940, may I continue, your lordships? Just read. Page 940 at paragraph 70, your lordships, the appellants clearly state it is adopted in examinations at the discretion of the petitioners and so further allege that no moderation scaling of marks carried out in the present examination. It is submitted that moderation or scaling is a method that enables rationalization of grant portals. It is adopted in examinations at the discretion of recruiting bodies which involve multiple optional subjects. However, no such moderation is required in the group 1 examination because all papers are mandatory and all candidates take the very same examinations. In the very same additional counter, they have stated that no moderation is required. Then during the arguments, they have stated about the fact that moderation in accordance with Sanjay Singh, the hawk-dove syndrome needs to be rationalized and neutralized. That is why they followed moderation. The learned judge came to a conclusion that because it's on page 306, your lordships, on page 306, it is the learned judge's decision. In the said additional common counter, para 70, it is said as follows. It is shockingly the commission has given contradictory statements, and the court understood that the commission did not follow any proper method and instead relied solely on its own selected expertise evaluators. The entire evaluation process undermines the sanctity of the group 1 examination. Now, your lordships, now that moderation has not been followed, even the hawk-dove syndrome, your lordships, another important aspect directly correlating to it, your lordships may turn to page 383 that the learned advocate general copiously went over. 383, and juxtapose the same with page 448. 383. Your lordships, for the first time, not even in the single judge's court, for the first time, we have been made aware of the fact that 14 evaluations, 28 evaluations are happening. Your lordships, and as is different subjects. Your lordships, the learned advocate general has stated at page 383, paper 4, economy and development, there is only one subject expert, economy and development. It includes 3 papers: Indian economy and development, Telangana economy, development and environmental problems. Your lordships, there is no, and they are on the same stand, there is no subject expert as far as development and environment is concerned. The reason why I'm saying your lordships may juxtapose with the same is at page 448, in their evaluation scheme itself, at 448, your lordships, is the tabular column, which says English has 33 evaluators, general essay 57, history, culture, geography, Indian society, constitution, governance, economy and development, science and technology, biotechnology, data interpretation also has a subject expert. But there is no expert for environmental studies, which is an integral part of economy and development, which carried 50 marks in general essay, that is in paper 1, and it carried another 50 marks in the subject essay, that is in paper 4. One person doing economy could not have had expertise and cannot have expertise in another completely different department, which is available with Osmania, JNTU and Ambedkar, your lordships. And hence, paper 4 cannot have just one subject expert, it needs to have 2 subject experts, your lordships. The other aspect is, your lordships,
Don't re-argue.
at page 371, I'm only clarifying the last clarification. Page 371, your lordships, the OMR 372 at clause 11.2, in addition to 15.2, 15.3, 15.5, 12D, 11.2 also, invalidation of OMR answer sheet. If any applicant fails to bubble or wrongly bubbles the question booklet series number on the OMR answer sheet, such answer sheets are invariably invalidated as answer sheets are valued by optical mark reader. This stipulation is to avoid any sort of human intervention in evaluation of scripts. This OMR was glaringly absent in the third evaluation. So if out of 28 evaluators, if at least a quarter of them are doing the third evaluation, their evaluation needs to be nullified, because there is absolutely no sanctity as far as the OMR is concerned.
The candidate filling OMR will arise only in the preliminary examination, where he will fill the OMR.
Correct,
The other
correct.
OMRs are to be filled by the evaluators.
Yes, your lordship,
Correct.
the evaluator OMR is missing, and the notification itself is a contract between the aspirant and the Public Service Commission.
I
The
don't
OMRs
think we
by
can stretch this that far, that it's a contract between the Public Service Commission and the candidate.
Yes, your lordship, the fact of the third evaluation is missing, and they have not been able to clarify. And the last aspect, the question that fell from the bench, Did we apply under RTI and representations? Your Lordships, pages 517 to 592. 570 to 592, we have many applicants who are part of my writ petitions have applied for their answer scripts, have applied for their answer scripts and evaluation patterns and made representations on the same as well. And none of them have been answered so far.
There are some more notes.
Only one point, Your Honor. I'm sorry.
एक काम करें ना, अब दोनों ही दे दो,
Very unenviable job, my lord.
That is why it doesn't get mixed up. Please let me do my own homework. So, learned Advocate General, this is the first one which you started with. Then,
And apart from that, my lord, I gave just one Sanjay Singh, my lord, Sunil Kumar judgment.
no, judgments are already there. Then the argument was by Senior Advocate Mr. Prakash Reddy. No, I understand. Understand. Then the argument was by Mr. Prakash Reddy, Senior Advocate. Mr. Prakash Reddy's. There is a compilation of judgment by him, but there is no separate. This one is by Mr. Prakash. Yes. Then there is Mr. Gopal Shankar Narayan.
Milords, I had given two one-page notes, one chart, and a compilation of judgments.
Just. There is one more note by him. Notes on data was given, some notes
Yes,
on.
one was note on data. The second one was propositions note. I can have it submitted again, Manoj, if it's.
No, it's
note,
there. It's
yes, note on data, propositions note, a chart on findings.
Yes.
Yes, Manoj, and a compilation of judgments.
There were two notes on data.
No, my lords, it's one. It may be two copies of it. I had given one.
Huh? Mhm. That you have given today only. Very well. Thereafter, Mr. Murlidhar, he's huh? Any notes? Then Mr. Niranjan Reddy, yours was there.
Mine was a 6-page note that I gave now. Mine was the
You gave
sweetest
now
one.
only.
Yes.
Very good. So these are of no, these are of the petitioners. These are of the respondents.
Lordships found it, no? Yes, I have. But it's titled as reply to the contentions of the respondent.
So now these are of the writ petitioners. Just check up because
Your Lordship,
anyone.
I've just given one.
This is by Mr. Surender Rao. Then notes on argument by Mr. Desai. Mr. Desai and P.V. Reddy. Rachna Reddy.
It's a written submissions and an IA3, Your Lordship. And
Mr. Vishnuvardhan Reddy.
cases and notes.
Then Mr. Naidu, Mr. Murthy, Mr.
I've
Naidu.
also given a case compilation today, Your Lordship.
This one.
Uh, Today, this one, Your Lordship, is very colorful and quite. I have highlighted every paragraph of it. Yes,
Yeah, this
yes,
one.
yes.
You give it once again with a clip. Give it tomorrow. And that 2-3 page note you give it tomorrow morning.
Tomorrow morning.
दोनों को अलग अलग
Given
बनाना.
these notes, Your Lordship, today.
हाँ?
Those are specimens of the.
Yes, yes,
Those-
specimens and
those
well,
loose.
21,085.
हाँ, I've kept it.
There are 7 papers. Give the details.
The written synopsis is filed by as Milord, Sai Present Gundavaram. That is also filed.
Record that all appearances, arguments concluded for pronouncement of judgment on 22nd January.
Subject to your lordship
Item
signed
115
permission,
not-
my lords. Item 141.
Huh?
Lordship's item 155 bar council elections matter, my lord, kindly have it tomorrow.
My lord,
Your lordship said to today morning after completion of this matter. Kindly have it tomorrow.
My lord,
But
my lords, 141
Item
also, my
169,
lords.
lords.
It has to be heard
Item 1.
separately, my lord.
huh?
Item 115, my lord.
Eviction.
Your lordship was pleased to.
Separate it
Item 169, my
after
lords.
20 seconds.
My, my lord,
Item
21st.
168
My lords,
and
it's
169.
eviction,
my
my
lords.
lords.
Your lordships heard in part this matter regarding regional transport officers appointment. Ms. Kalyani argued the matter, my lord. I have to
Eighth.
argue. Kindly have it, my lord, since last three
8th
occasions.
January.
My lords, eviction is
Right.
hanging on my head, my lords. Item 141. Tomorrow, my lords.
Which one?
Item 141, my lords. Today, which I
Tomorrow.
mentioned.
Next
tomorrow.
next week, my lord,
Deeply
141. We for official respondents.
Achha, this 141, keep it in the reopening. 5th January.
155 lordships. 155 lordships may have it tomorrow.
All-
Bar council elections.
So how many times we'll keep it tomorrow?
My lords,
You-
141 tomorrow, my lords.
Obliged.
Grateful
I'm
for
deeply
your
obliged.
lordship's time. Grateful for your lordship's